This courtroom isn't calm today. Every case tells a story, tension, delay, and decisions that could change lives. Watch closely as lawyers battle deadlines, judges weigh patience against justice, and emotions start to leak through the formality. Stay sharp. What looks routine now might explode into something bigger within minutes.
Okay, sure. Adjournment. Study adjournment. We study.
Oh, okay.
What is really going on?
I will tell you, Your Honor, at this time, I am gonna ask for an adjournment of this matter. Late yesterday, we did get an offer and had already visited with my client. I want to convey that to him. He wants a 1 week adjournment to consider though, because he was ready to go to exam is where the issue is coming in at. And I do have.
Sir, can you state your name?
Randolph Taylor.
Thank you.
Oh, sorry.
No, it's okay. You just started talking.
I did.
That.
I did.
You don't even let everything. You just start talking. I don't even know what you're talking about.
Yeah.
I'll give him the 1 week adjournment under those circumstances.
Yes.
Yeah.
Sorry, I didn't sign it, Your Honor. I'm sorry.
So it's half filled out.
It was 2/3.
No. I don't even know what this says.
It says you are awesome. So,
Probable cause conference will be adjourned 1 week out to the 13th,
thank you, Your Honor.
2025, 9 a.m. Bond continued. Thank you, sir. Court calls the case of the people versus Jermaine Johnson.
Assistant Public Defender Sandra White on behalf and not with Jermaine Johnson. I have spoken to him this morning. He said yes, several times.
How was he doing?
I was out there one time when you called my case.
So he was here?
No, I was on the phone. He's not doing too well. He said he's homesick and he was trying to get a ride.
So has a bond violation.
Yes, I did make him aware of that. So we are asking for an adjournment. I did do a green sheet.
That's okay. I don't need it. Bench warrant will issue for defendant's failure to appear. Bond is setting about $25,000 cash surety. That warrant will issue immediately. But
why so high, Your Honor?
You want me to give me 50?
No, I'm good.
Okay, all right. Thank you. I don't remember what happened to the last attorney that asked me that. Haven't seen him since. Court calls the case, people versus Andrew Travis. No, we'll wait.
Public defender, not the kid. The prosecutor.
Yeah, he already did that like ages ago, waiting for you.
It's not the carry. I can rule, Your Honor, on behalf of Mr. Andrew Travis. Mr. Travis, state your name for the record, please.
Andrew Jacob Travis.
Thank
Your
you,
Honor.
sir. I have before me a plea form that indicates that the defendant will be pleading guilty to an added count 2 of attempted.
Here's where legal reality hits hard. A guilty plea isn't just paperwork, it's a full surrender. Every yes, Your Honor, carries years of consequence. But notice how the judge walks the defendant step by step, making sure it's voluntary. That's justice's fine print. You must understand the price before you pay it.
Andrew Jacob Travis.
All right, sir, it is this court's understanding you're going to plead guilty to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. Do you understand that?
Yes, I do, Your Honor.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in 1418 District Court. You understand that?
Understood.
So was plead guilty?
Yes, I do.
And to that charge, how do you plead?
I plead guilty, Your
Now,
Honor.
you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, I understand.
All right, you signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, but I do have matters in Wayne County right now. But I'll be honest, Your Honor, I'm kind of fear for my safety in Wayne County. I just wanted to put that on the record, so I don't know if anything could change where I do more time in Washtenaw. I just wanted to put that on the record.
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
No, Your
Has
Honor.
anybody threatened you or coerced you in any way?
No,
You're doing this voluntarily?
of my own free will.
Okay, involuntarily? Yes?
Yes, voluntarily.
Because you believe also that you're guilty of this offense?
Yes.
On the date of October 2nd, 2025, at the location of 128 North Normal Street, City of Ypsilanti, Washtenaw County, State of Michigan, did you come into contact with officers from the Ypsilanti Police Department?
Yes, I did.
What happened?
I resisted their arrest when they tried to detain me.
Okay, they were trying to arrest you?
Yes.
All right, and so they were performing their duties.
Yes.
And in what way did you resist them?
In what ways I wouldn't put my hands behind my back when they gave me a lawful order.
Okay, so they were telling you to do something and you just wouldn't do it.
Correct.
All right. It didn't work out well, I bet.
No.
Okay. Sir, if I accept your plea in this case, between the time of your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, the court would no longer be required to follow any sentence evaluation or recommendation in this case, and you would not be entitled to withdraw your plea. You understand that?
Understood, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
Neither is defense, Judge.
Have I complied with the court?
Defense is satisfied as well, Your Honor.
All right, court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1482 probation. Sentencing in this matter will be
December 10th at 10 a.m.
December 10th, 2025, 10 a.m. before Judge Barr.
All right. Thank you, Your Honor.
Thank you. Bond will
Your Honor.
continue. Thank you, sir. Good luck to you.
Thank you so much, Judge.
Have a good one.
Court does call the case of the People versus Sandra Law.
This next exchange feels different, quiet, almost fragile. Behind every motion and bond continued is a human life balancing between freedom and control. The judge's calm tone hides the tension of real people fighting second chances. If you were standing there, would you plead for time or face the verdict head on?
What are we doing on Ms. Law's case?
Well, Your Honor, we are working on the case. She does have a bond violation. The court is
Yes.
well aware of it. We did receive, and I did provide the prosecutor.
Counsel
Or-
approach.
The Sandra Law hearing unfolds like a slow burn. 2 failed tests, 1 hospital stay, and a bond now revoked. The courtroom goes silent. Justice doesn't always roar. Sometimes it whispers through consequences. Addiction, treatment, accountability. It's all colliding here. Would you see this as punishment or a chance for redemption?
Record in the law matter.
Yes, Your Honor.
What I'm gonna do is, we've had a bench conference in this case. I'm going to adjourn this out 1 week to November 13th, 2025 at 9 a.m. However, on September 25th, she tested positive for cocaine or other drugs, but my understanding is that medication. That's on September 25th. October 1st, she then tests positive for alcohol. So I have those 2 consecutive tests, or those 2 tests where she's got something in her system she's not supposed to have. And then I don't have another test from her.
Yes, Your Honor. I do understand that, and I will be providing the court with some medical records indicating that for a very good chunk of this, she was actually hospitalized. But my view of it, in truth and candor, does not indicate it for all of it, but for a very good chunk of it, she was hospitalized. And Your Honor, I will do an order for inpatient treatment to see if that'll work for this court.
It may, but at this time, given what I'm seeing, I just put it over 1 week. You can get that information to me, but at this time, defendant's bond is revoked and it's remanded.
Thank you, Your Honor.
Recalls case of the People versus Suzette Hampton.
For the people. Can state your name for the record, please?
Suzette Hampton.
I knew you would show up. Everybody else had little faith in you. I said, Miss Hampton's gonna be here. I'll pass this matter.
I couldn't hold it any longer. I'm sorry.
What'd you say?
I couldn't hold it any longer. I'm
No, it's
sorry.
okay. It's okay. I knew you were here. I knew you'd come back. That's right.
Yes.
Everybody else didn't know. Everybody else thought you took off.
Oh, no.
But no, I had faith. All right.
Judge, did I give?
Okay, that's
I-
not how that really. But anyway,
We'd like an adjournment. Does the
were
court
you looking
have?
for your green sheet?
I was.
I already have it.
I thought
They
so.
called
I
the case
knew
and you
it.
gave it to us.
I did. Okay.
I know
yeah.
it's shocking for you. How much time do you be looking for?
Judge, if we could get like a month, I mean, we're working on mitigation.
We're asking for a lot.
Listen closely to the judge, and Miss Hampton humor mixes with relief. It's rare warmth in a cold system. But beneath the smiles, real stakes remain. Every adjournment means more waiting, more uncertainty. So tell me, is patience in the courtroom a virtue or a strategy? Drop your thoughts below.
Morning, Your Honor. Mike Getty, Assistant Public Defender, on behalf of Mr. Vasher, who's here to my right. State your name, Mr. Vasher.
Thomas Basher. All right, thank you. Yes, sir. Question and adjournment.
Yes, Your Honor. And we are requesting a release of treatment. I did submit an order to that.
And if you submitted it, I would have signed it. Mr. Basher needs to get himself in. So I don't have a problem with that.
Thank you, Your Honor.
And you said there was a global resolution.
Yeah,
The other cases, how much time do you think you'll need to try to wrap up?
maybe 3 weeks, Judge.
3 weeks. I'll give you the 25th or December 4th. Which would you prefer? It's like 2.5 weeks and
December 4th.
December 4th. Okay. Probable cause conference, December 4th, 2025, without objection. 9 a.m. Bond will continue. All right. Thank you, Mr. Basher. Mr. Getty,
I can resend it if you like, Judge.
well, hold on. No, I did sign an order modifying, but I did.
Oh, thank you, Judge.
You're all set. Court calls the case, People versus Sean Logan.
Sir, please state your name.
Sean Logan.
Your Honor,
Yeah.
may I approach with the prosecutor?
Well,
it-
what are we doing?
Well, he's waiving exam, but he also has a bond violation.
Yes, he does.
And he has a medical card that I wanted to share with the court also. And I wanted to share some other things with the court that I didn't really want to put on the record.
Then comes the storm. A defendant speaks of abuse inside the jail, and the judge dismisses it instantly. It's uncomfortable, raw, and real. Who's right here? The man pleading for help, or the system protecting its own? This moment divides viewers' truth versus reputation. It's a reminder. Justice isn't always seen, it's felt.
The offense alleged was committed and that you committed it.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive the right. Preliminary examination having been waived, defendant bound over to circuit court on count 1 with 2 following.
Ron Brown appearing on behalf of Sean Logan, waive reading, stand mute, request pretrial in circuit.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea to both counts. Pretrial will be set for
January 8th at 1:30, which is what?
January 8th, 2026, 1:30. Judge Slay.
Thank you.
Thank you.
Thank you, sir.
Bond con-
Thank you.
Court calls case People versus Sean Beater.
Ashley Feltus for the people.
Mr. Beater, will you state your name for the record?
I've been being sexually abused by certain guards at the jail, and I just want someone to know who can help prevent that from happening in the future. My name is Sean Veter. Wanted you to know because you're an authority figure who might be able to prevent such actions from happening against inmates.
Sir, you have a process. First of all, I do not believe you. And I'm just going to let you know that because I know many of these guards and many of these folks here.
Not all of
Fine
them, just
people.
certain ones.
There's a process. If you believe that to be the case, there's a process through the jail by which you may make that complaint without trying to disparage the reputation of all of these fine officers.
It's not all of them, it's
Washington County
just a few of them.
Sheriff's
Most of them are
Department.
good people.
I'm done with it. I've told you to use the internal procedure. What are we doing on this today?
Your Honor, Mr. Veeder wishes to waive his right to a preliminary examination.
Is that correct, Mr. Reader?
Yes.
You understand that that's a proceeding where the people would have to show by probable cause that the offense is alleged
Same
was
guard.
committed and that you committed. You understand that?
What was that?
I'm sorry, Judge, I mentioned something to him.
What were you
regarding that,
saying?
if you could
I was
restate
trying
that.
to hear everyone at the same time.
You understand that a preliminary examination is a proceeding by which the people would have to show by the standard of probable cause that the offense alleged was committed and that you committed it.
Yes.
You understand that waiving that, you will not have that hearing and that you'll proceed to circuit court for further resolution.
Correct.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count.
Your Honor, we acknowledge receipt of the information, waive its formal reading, and ask
To
this
the
matter be
truth.
set for a free trial.
Defendant having waived formal reading, standing mute to the charge, court will enter a not guilty plea. Pretrial will be set for
November 17th at 1:30.
November 17th, 2025, 1:30 before Judge Hamud.
Speak the truth.
I understand. We'll talk with you about it. Thank you.
Bond will continue.
November 17th, Your Honor? Yes.
Yes. Court calls case People versus Jack Saunders.
House of Office for the People.
Jack Sanders. I know you would have been right up here, but Akin really was talking in your ear, wasn't she?
Hello, Judge. Ronica Glenn, appearing on behalf of Mr. Saunders. He is not present today.
He's not present.
Now, so we are asking for an adjournment or at a minimum a show cause.
Really? Did she tell you to ask for a show cause?
Yes,
Who did? Cannon said
Yes.
to ask him for a show cause?
she sure did.
So she was trying to set you up. That's okay. I got your back. Bench warrant will issue for defendant's failure to appear bond is set the amount of $10,000 cash surety. That warrant will issue immediately.
Okay.
She did not hesitate not to protect Cannon. She sure did. Just set me right up. Thank you.
Thank you, Judge.
After hours of tension, rulings, and raw emotion, this courtroom finally falls silent. Every case today, from missed hearings to broken trust, revealed one truth. Justice never moves without consequence. Some left with second chances, others with shattered ones. If this left you thinking, hit like, drop a comment, and subscribe for more real courtroom stories.